Suppose the class began the day the case walked in the door. It's the first day of the first term of the first year. The professor has just announced there's a new client who's coming in for an initial consultation in 2 weeks, and the class needs to get ready. So meet Lee Taylor. Oh, no, sorry. That's not Lee. That is an advertisement from Southern Living magazine about the fictional blockbuster diet drug Aspire. Lee is a 40-something mother of 2 who decided to lose that extra 20 pounds prior to her daughter's wedding. Her doctor prescribed Aspire. Well, Lee lost the weight, but she didn't attend the wedding. She was in the hospital having just had a heart attack, and the damage to her heart was disturbingly similar to that discovered and published in New England Journal of Medicine article about patients who had taken Aspire. Unfortunately, there's nothing in Aspire's label, patient medication guide, or package insert that indicates that Aspire causes heart valve damage. So the students start out the term with a high-level overview of torts, a number of cases that indicate the kinds of claims that someone who had taken a defective drug might have against multiple defendants. And then they interview Lee. And at that point, to start to write some rudimentary kinds of allegations for a complaint that they will perfect later on. In the process, they start to notice some interesting things. First, the state of Euphoria's long-arm statute happens to permit personal jurisdiction over defendants who have engaged in tortious conduct in the state. Ah, well, there you go. Further, defendants may be held liable for injuries caused by defective drugs if they placed those drugs in the stream of commerce. But the stream of commerce is also going to be used to determine whether the state's courts have personal jurisdiction over that defendant. Foreseeability? Oh, well, that's just everywhere. Students begin to notice that the law is not just a matter of isolated rules and siloed subject matters, but is actually an interconnected web of principles, concepts, and rhythms. Well, if you're noticing those things, you probably just walked into Introduction to Civil Litigation, a 10-credit, year-long first-year course at Arizona Summit Law School. Introduction to Civil Litigation integrates topics from civil procedure and from torts. And one iteration of the course integrates a year-long simulation of litigation. That's Lee Taylor's case. All right, now many of you are probably thinking, we're not ready for curriculum reform at my school, so this program is not for me. Well, I mean, whose school is, okay? But I've done almost all of the things that I'm going to talk about in this session in my traditional courses, versions of them. You can too. All right, so let's go ahead. Integration is really about the blurring of boundary lines between, say, 2 subjects, and also what we in litigation call doctrine and skills. Horizontal integration is the integration of subject matter, such as torts and civil procedure. Vertical integration is where a professor brings in authentic learning activities to animate the subject-subject integration involved. You can even integrate an entire curriculum. What happens then is individual learning opportunities build on one another throughout the curriculum, so that in this logical progression, the school produces this sort of ideal graduate who's then ready for practice. A number of professional schools are starting to adopt integrated curricula, such as medical schools and business schools. There are a lot of reasons for doing this, and in fact, a study actually indicates that maybe integration would be good for something like law schools. First of all, integrated courses of course, naturally, get students to make connections between topics. Well, those connections are like rocket fuel for more complex problem solving. Then, by their nature, integrated courses require active and deep learning, which is what helps students to retain the knowledge that they get. Then there are all kinds of opportunities with integrated courses to develop professional, intellectual, and interpersonal capacities. And finally, in vertically integrated courses, students also have the opportunity to work with these more authentic assignments. And authentic assignments are what causes students to be able to transfer knowledge from one situation to another. I mean, the bottom line, though, is that integrated courses just help students learn things better and more deeply. Now, you do not have to integrate entire courses to get some of these benefits. You can do it right in the traditional course by integrated topics, or there's some other ways as well. I don't know how many civil procedure professors we have here, but imagine you are one. I promise you, every week you will have a dream at night that you were teaching pleading with a substantive subject matter that requires students to do precise fact analysis. Well, guess what? Your torts colleagues are frustrated all the time because they can't get their students to do precise factual analysis when they're teaching cause in fact. So quit dreaming and being frustrated. Get together. One of you teaches pleading while the other one is giving a memorandum assignment on causation in fact law for a particular negligence hypothetical. Then join forces in the classroom. Then give a, say, pleading assignment where students write allegations right there in the classroom for cause in fact in that particular hypothetical. Well, the torts professor is going to be so pleased because you can't write pleading allegations without doing active, precise fact analysis. And then you never need to dream again, civil procedure professors, because you can just watch the Twombly-Conley standard come alive in the classroom. Now, Introduction to Civil Litigation is also a spiral curriculum. The benefit of a spiral curriculum is it helps students construct knowledge in precisely the ways that's important for complex problem solving and higher order thinking. A spiral curriculum is what it looks like. It is a horizontally and vertically integrated curriculum in which topics spiral back around throughout the course of the term or the period of instruction. So take a look here at, in blue, the subject matter jurisdiction, and in the red, duty. Those two topics get taught separately at first, but then they spiral back around and meet. Here's what happened. Lee Taylor filed her complaint in state court and brought a claim against her pharmacist, who happens to be a citizen of the same state she is. Well, it's the only defendant that is. And let me tell you also about failure to warn claims, sort of generalized ones. They're kind of speculative, okay? Well, what's going to happen? The defendants are going to file a notice of removal on the basis that the pharmacist is fraudulently adjoined. Lee will have to follow up with a motion to remand to explain why there may well be some merit in her claim against the pharmacist. And so it brings those topics together at a higher level of sophistication because that's what an authentic learning activity is. But now also they're having to deal with them at the same time. But look, they spiral back around again and show up in the pleading assignment, which is pretty sophisticated because look at all of the topics that join in together to write a complaint. Okay, so those are really the benefits of spiral curricula, and they're really very fun for students. Now, if you want to try this integration thing, here's what you should do. Pick out, in whatever you're trying to integrate, pick out the points of integration that you see. These points of integration will tell you in what order you're going to teach topics and the methods that you're going to use to do so. I call that the spine of integration. This is the spine of Introduction to Civil Litigation. Now, several of these combinations I've talked about before, but there's two up at the top that are worth looking at because they describe some different things than we've seen. First is, and I know you're thinking, what implausible connection do the Erie Doctrine and premises liability have? But they do see, because don't forget, Erie versus Tompkins was actually really a premises liability case gone wrong. And the benefit of using them together is you can teach premises liability And if you assign the entire opinion of Erie versus Tompkins, it actually gives a good summary of premises liability law. Then as you move into Erie, because you've already dealt with the first part of the case, students are going to understand the forum shopping concepts and the conflict of law that really got the Erie case to be relevant. Okay. Then, what I really like are forms of integration that cause people to be able to use the rules to get things done. A good example of that is the pinnacle of integration in Introduction to Civil Litigation: causation and summary judgment. Now you can imagine how they integrate in the first instance, because really you can't actually separate summary judgment from substantive law anyway. They really go together. But also here, we give this a chaser of Erie doctrine as well to animate this assignment. Well, Lee did discovery and it didn't come up with a whole lot of causation evidence, unfortunately. Right, there's some, but she's really worried that she's not going to be able to survive the federal summary judgment in federal court. But the state of Euphoria has a more lenient standard, and she may be able to meet that. Well, the inevitable motion for summary judgment comes down. And her response is going to be twofold. First, she's going to argue that the state standard needs to apply in federal court. Well, that will be a challenging assignment, let's put it that way. But then, of course, whatever standard's going to be applied, she has to show that her causation evidence is sufficient to meet that standard. Okay, I am with you. That is a difficult assignment. It's a complex problem. But at this point in the course, students can do it. Thank you.